Dr. A, do you want to test your microphone?
Yes, I'm present.
Okay, sound good. Thank you.
Good morning, good morning, good morning. Testing, we're on the record. Good morning, it is 9:36 a.m. and I would like to call today's hearing to order. Let the record reflect that a quorum of the hearing board is indeed present. The two members of the hearing board who are participating remotely. Dr. Abraham, I am looking at the agenda, so it's safe to say that your item was posted pursuant to the traditional Brown Act, correct?
Correct.
And the building is indeed accessible to the public?
Correct.
And no one over the age of 18 is present with you today, correct?
Not with me right now.
Okay, very well. And Ms. Verdugo, proud to your participating remotely via ADA, correct?
That's correct.
Okay. The two hearings on the docket, actually one hearing on the docket, a reconserve of California case number 2876-8. And then there's another matter that pertains to hearing board business, proposed administrative amendment to Rule 4B4 of the Rules and Procedures. All right, Madam Clerk, are there any individuals online before we lay out the exhibits? Just want to confirm that no one has sought recognition to provide general public testimony or evidentiary testimony. Okay, very well. There's several exhibits. We'll call those exhibits out. So the first, petitioner's exhibits. 6 is the updated chronology. Petitioner's exhibit 7 is the updated excess emissions calculation. Petitioner's exhibit number 8 is proposed regular variance conditions. Okay, wait 1 second. So that was the okay. So shouldn't those be one is shouldn't it be alphabet? So the
petitioner is number, and then for the respondent,
okay. So there were 2 emails sent. Were there any additional? Right.
There's another one, legal fees, that will be proposed, regular variance conditions, and that's from the district. So you should have 2 copies of the proposed variance conditions, one from the respondent and from the petition.
Okay, so in the email, it states that the petitioner's exhibit was 6, 7, 8, and then there was an additional, 2 emails saying that, no. All right, it was just 2 emails saying the same thing. Now, the district's exhibits, were the district exhibits?
Sent earlier with the 2 other documents that's from the petitioner. 6, 7, and 8 from the petitioner.
Correct. So there was a 725 email.
And the one more recent is from legal.
Okay, so the one more, the recent would be D. Yeah, because what I have is there's a 743 email that says exhibit 6, 7, and 8. Sure, absolutely, absolutely. We're going to recess for about 2 minutes. We're off the record.
Yeah, I just sent it to you.
Okay, cool.
All right, we're back on the record at 9:40. back on the record at 9:40. So then the respondents exhibit would be B. Respondents exhibit is proposed interim various conditions. And again, that's numbers 1 through 12. You have a copy of that, right?
And I believe they verbally said before we got here that it actually should say regular, not interim in B, and B is missing section 12. Otherwise, it's,
Intention.
okay.
Okay, so just so we're clear,
Oh.
it'll say proposed variance conditions. Right? Okay, so we're clear for the record? Madam Clerk?
What is today? First, 14, 21, okay.
Okay, perfect, perfect. Good deal, good deal.
Let me clarify. So the ones that are from the district is the one that was oh, interim, that should be corrected.
Right.
And that should say regular, so this is the district. And then the other one. So for number 8, that is correct, it says the most regular variance condition.
Yes.
That's the word.
Right, we're good to go. All good, all good. Teamwork. All right, who's here representing the petitioner?
Good morning, Chair and members of the hearing board. Maya Gross on behalf of Reconserve.
GR.
ASSE.
Who's here representing the executive officer?
Good morning, Chair, members of the board, Mary Reichert, on behalf of the executive officer.
All right. Ms. Gross, it's your case.
Thank you and good morning again. I'm
Oh,
here.
I'm sorry, any witnesses?
Oh, yes, thank you. We have 2 witnesses that are online to be sworn in.
Okay, so why don't we go ahead and administer the oath? I assume there's some witnesses on your side too, Ms. Riker?
Yes, I have one witness.
Okay, so why don't we go ahead and stand, have all the witnesses, whether you're online or in person, stand. Okay, raise your right hand. Do you solemnly affirm that the testimony you're about to give of this matter is the truth, the whole truth, and nothing but the truth?
I do.
All right, let the record reflect that there are 3 individuals, 2 online, 1 in person standing, and they've accepted the oath. All right. Ms. Gross.
Thank you. I'm here today on behalf of Reconserve of California, Los Angeles, Inc. Reconserve came before this board on May 27th, seeking an interim variance from Rule 1147 NOx limits, which this board granted. At the outset, I'd like to request that the evidence and exhibits from that hearing be incorporated into this regular variance hearing. And based on my conference with counsel ahead of time, the district, I believe, does not oppose, but we can proceed to that. But that would streamline this regular variance hearing because we had quite a bit of testimony in the interim variance hearing that covered both good cause. Oh, okay, thank you. Yes, that covered the good cause as well as the findings. Reconserve is now requesting a regular variance to allow them to operate while they await delivery of their new ultra low NOx burners for their dryer and RTO. And as you'll hear in the testimony, they anticipate installing these months sooner than previously expected. And as you heard on May 27th, Reconserve is a business with a unique role in our community. They recycle large volumes of baked products from industrial bakeries and process it into an animal feed ingredient, which is depended on by California's agricultural and industrial dairies, especially, as well as industrial bakers to receive those products. The process uses a dryer and a regenerative thermal oxidizer, RTO, which controls VOCs from the process. And those use burners, which are in the process of being replaced. You'll hear from the same 2 witnesses today as last time, and we very much appreciate the board's accommodation to allow them to appear remotely since they're both based out of state, and appreciate the district's accommodation as well. First, Keith Rudd is Vice President of Environmental Health and Safety for Reconserve, and he's based in Texas. Although we heard a lot of testimony from Mr. Rudd previously, he can speak to the facility's operations and the role in the manufacturing and supply chain, the impacts of the potential shutdown, and history of interactions with the Air District. And he'll also speak to the expected compliance timeline and the request for a modification of one of the conditions that's in our proposed Exhibit 8. The second witness is Shara Dine, who is Reconserve's air quality consultant. Again, you heard from her in the May 27th hearing, and she's been the primary point of contact for Reconserve Los Angeles beginning in late 2024. So she can speak to the history of communications with the Air District and Reconserve's understanding of the rules and options available to it, as well as she'll provide an update on the excess emissions that reflect a realistic estimate of emissions if this variance were granted. As you'll hear under Reconserve's proposed condition, increasing the therms from 18,000 to 21,500 per month, the excess NOx emissions from that increase would only be about 1.1 pounds per day total, which is only 0.19 pounds per day more than the existing condition. But it would allow them to better prepare the facility to receive the new burners and install them quickly. And as you heard from testimony supporting both the good cause and the 6 findings for the interim variance, the reason Reconserve is before the board today is due to a combination of circumstances, earnest misunderstandings, and a learning curve to climb with district rules, processes, and procedures. And they have done a lot of climbing in the past couple of months since that time. Reconserve had extensive conversations with staff in the course of their reclaim compliance and testing and inspections. The recap essentially of the testimony, as you'll recall, is that despite these extensive compliance over years, they did not realize that there had been a change in the emissions limits that applied to them for NOx under Rule 1147's 2022 amendment. And while they were still getting feedback and notices and inspections on the reclaim side of things, it wasn't until they went to amend their permit to do some cleanup exercises in the permit that it was first brought to their attention that there was a compliance issue. And they also didn't realize that their extensive touch points with reclaim staff did not carry through to permitting and engineering staff. And we went over all of that in the prior hearing, but can certainly address those questions for you again if needed. But ultimately, they always sought to work collaboratively with the district and didn't realize that the variance process was available to them until shortly before they filed the petition for the May hearing. And so that's what brings them here today. And they understand in hindsight much more about this process, and they look forward to coming into compliance here. And as the board weighs those factors, we also touched upon the harms that would result if the variance weren't granted. The witnesses will be available for testimony on that. And since the interim variance hearing, Reconserve has operated essentially in a curtailment mode, limited to 18,000 therms weekly per condition 2. And while Reconserve is willing and able to curtail operations somewhat during the variance period, Reconserve is requesting an increase in the therms limit for the regular variance period to 21,500, which will allow it to process the raw material that it's accumulating so that it can get down to 0 raw material before it's time to install the burners. And while this curtailment would not obviate the need for a variance, it would reduce excess emissions compared to if they were not curtailed, as Ms. Dine will testify to. And you also hear that the burner schedule is accelerated from the last hearing. Previously, they anticipated that they would need until late May, a full year for the regular variance based on the burner's expected delivery in October. But they've been diligently following up with the manufacturer, and through circumstances, they now expect completion by January 31st, 2027. And the burners are expected to be delivered even as soon as August. And so that schedule is both ahead of time and still builds in a buffer in case there are challenges, particularly during the busy time, which is around the holidays. We appreciate the hearing board's consideration of this testimony and would request that the prior hearings testimony be incorporated as well as the evidence. Thank you.
Thank you, Ms. Riker.
Good morning, Chair and members of the board. Preliminarily, the district is not opposed to incorporating testimony and evidence from the interim variance petition. That said, the district is opposed to the granting of this regular variance for this basically the same reasons articulated at the interim variance hearing. This facility has been out of compliance for 6 years. They claim ignorance, and as this board well knows, ignorance of the law is not an excuse to compliance. All other regulated facilities in the district are required to comply and to affirmatively make sure that they are aware of any and all rule changes. And then even when they were affirmatively notified that they were out of compliance in April of 2025, they delayed and tried to find ways around complying with the rule. And despite repeated urging by staff that they were out of compliance and needed to replace the burner, it took more than a year for them to come before this board. We do not believe that the facility was acting in good faith during that time, despite the board finding that there was that the violation is beyond their reasonable control. The district does believe that they could have and should have taken action earlier, and had they done that, they would be in compliance today. So for those reasons, the district is opposed to the granting of this variance. Thank you.
Ms. Gross.
I'd like to call Mr. Keith Rudd, please, as the first witness.
Good morning.
Mr. Rudd, could you please state your name and also spell it for the record?
My name is Keith Rudd. It's Keithrudd.
Thank you. And just to confirm, have you taken the oath this morning?
I have taken the oath.
Okay. And also, just to confirm, you testified previously at the May 27th hearing, is that correct?
That is correct.
In the interest of not retreading ground that we've extensively covered, I just want to very briefly recap a little bit of the history that you testified to previously. Can you just recap for us your experience in working with the Air District staff in connection with the Los Angeles facility through its reclaim process, as well as the more recent permit amendment process, and what your understanding was regarding compliance, pathways towards compliance, and generally that topic?
Yes, ma'am, I will. So when we started, our initial reason for contacting the district was we wanted to remove a piece of equipment from our permit. And our contacts have been primarily with the reclaim, is it division or section, I guess you'd call it, portion of AQMD. And we were working through that process and having those discussions. At that time, we had no idea that we were out of compliance. And you know, we were working through, and then it changed. We went from the reclaim folks to the engineering folks, and we genuinely had no idea that we weren't with the right people. From our perspective, it's all AQMD, and we know better now, And we understand much better now, but, you know, in many cases, you know, in other states, we deal with one person for everything. That one person will come and do our inspections, they'll do auditing. You know, if there's an issue, you know, they will be the ones to contact us with concerns. And if it goes further, then, you know, they would be the ones to contact us with any violations that they were to find. So we didn't really understand the dynamic internally within the AQMD. And we appreciate that this is our issue, not their issue. We understand that, but it doesn't change the fact that you only know what you know. And
Thank
when
you.
we got with the folks for permitting, you know, after some back and forth, they asked the question about 1147, and we had no idea what they were talking about. Since then, we've climbed a vertical ladder of information, and beginning to understand, you know, kind of the who, what, when, where, and how of what goes on and how we should have done it in the first place.
So is it fair to say, based on your experience over the last couple months, that you are approaching compliance differently with the air district and the LA facility?
Significantly differently.
Okay, thank you. And also just to clarify as well, when you were working with staff and first understood that this was an issue, that staff had identified a concern, were you attempting to hide the ball or delay any sort of a process? What was your interactions with staff?
No, absolutely not. When they raised the issue, you know, we first had to understand what is 1147, and then from there we had to understand, are we compliant or not, because we did not have testing under that protocol. You know, if you look at how the RTO is tested traditionally around the United States and previously in the state of California, the RTO would have easily passed, because when it's in low flame mode, while it's, you know, self-sustaining, the emissions are very, very small. And so we didn't really understand what that change would do. And I'm not here to argue about that change today. Please understand, I simply am stating that that's where my head was. I mean, that's what I knew at the time. And so we began to schedule testing and to determine if the facility is in fact in compliance.
Thank you. And just to also confirm again from the last testimony, you've already ordered new burners, and you did that quickly as soon as you determined that you were not in compliance, correct?
That is correct.
Okay. And then I want to ask you about the operation of the facility. How often do these burners typically run at the facility?
You know, it varies seasonally. It depends on the material, right? So typically they run 2 to 3 days out of the week. The dryer burner. So the RTO will run for about 2 hours at heat up, and then we'll go into a dormant mode until we begin processing material. When we process material, then there's a very short time that it would still be in natural gas, and then it would go into what is considered like a self-sustain mode, where it is burning the VOCs and it's self-sustaining itself on the VOCs.
Okay, thank you. And I want to just touch on the proposed therm limit, which goes to the issue of curtailment under a variance. Currently, under the interim variance, you're operating with an 18,000 per week therm limit. Can you explain a little bit about how this has impacted operations at the facility?
Yeah, so it limits the number of hours that I can run the plant. what it does, and that's causing issues. We're having problems with inventories. So, you know, the inventories fluctuate from day to day, and certain days of the week are bigger receiving days than other days. And I need, in order for my plan for the burners to be replaced, I need to be at as close to zero as possible on both my raw material side and on my finished goods side, my finished feed ingredient side. And I'm fearful that based on what I saw in the last month of running at 18,000, that I'm going to be in trouble when it comes time to change out the burners because of how the material comes and what it does. You know, we take material from the local bakeries, and we take that in two phases. The initial phase, like I testified before, is when they're like for the holiday coming up, right, for Thanksgiving, you know, is the next big one for us. You know, the bakeries make all the stuff beforehand so they can put it on the shelves. And so when they have mistakes or problems in their processes, that material comes to us. And so there's a rise in material then, and then there's a lull. And then after the fact, there's another increase in the material as it comes in. And that's what didn't sell. It's what's off the shelves. And the reason that it's more critical right now than it would be if this were January, you know, or February, is because the second half of the Thanksgiving rush, if you will, coincides with the first half of the Christmas rush. And so they overlap. And so I wind up getting significantly more material during that time frame, and I need to be able to process that. And you know, if I've done my math right, which I believe we have, you know, I believe that we can get through with the additional storage unit, or with the additional storage rather, at 21,500.
Thank you. And just to correct, I misspoke. I said 18,000 per week, but it's 18,000 per month. Thank
Yes,
you.
that's correct.
And so going to 21,500 therms, is that, and looking at the seasonal variation, would that still be less than what you may expect to ordinarily operate at between now and, say,
Yeah.
January 31st, when we expect full compliance?
Yes, that is correct.
Okay. And speaking of looking forward with compliance, I want to just ask you about, you know, kind of what you're doing generally at the facility with the burner project and preparing to receive the new burners, and what you would be doing under the variance.
So we've put a lot of pressure to remove finished product that we have in stock to make room to ensure that we are in that position. They're also working with the local bakeries much more closely to ensure that we are not surprised by anything that you know, if they have a new line that they're about to start up, or if there's, you know, because when they do that, when they're proving out the new lines, we get a massive amount of material in that scenario. We also have changed our the makeup of our product to where that there are, you know, we've reduced supplements, you know, which is injurious to us in a monetary form, because there's material then that we're not using, that we're not making money on.
Okay. So you'll, even if you get this 21,500 therm limit during a regular variance period, it would still be a bit of a financial impact, but would allow you operational flexibility. And can you talk to us a little bit about the burner timeline, the burner replacement timeline, as it's been updated since the interim variance hearing?
Yeah, so through some diligent work by the local general manager at the facility, working with the vendor who's going to do the installation, they've worked with the manufacturer of the burner themselves, and they've been able to secure a delivery date at the end of next month, at the end of August versus at the end of October. And, you know, so that's how we believe that we can be done by the end of January, on January 31st. We've also, you know, through some better understanding now of the various rules, we've also realized that we don't have to wait till one step is done to do the next step. We can do some of the steps concurrently. And so we're doing some of that, working with the, as an example, the source test people. We're prepping that and trying to get on the schedule early so we can limit the amount of time required.
Great, thank you for that. And just very briefly, because we touched on it a fair amount in the prior hearing, but if you're not granted a variance and you need to shut the facility down until January, can you just, in a couple sentences, remind us the consequences of that, both for your employees and the community and the industries?
So from an employee standpoint, you know, there are multiple employees, approximately 20, that would be unemployed. They'd be laid off. There'd be no job for them. And some of those are 20 and 30-year employees. You know, and a lot of what our employees do is very specialized. So there aren't necessarily some transfer of skills where they could just go work someplace else for a while and then come back. As far as the food chain, it would be extremely detrimental. You know, they have about 3 to 4 days of storage on their end, and then they shut down, and it takes about 3 days from the time they bake a loaf of bread till it hits the shelves, or cakes, or whatever it is that bakery makes. And so it you'll begin to see bread disappear. And then further on the other side of the coin, you know, there's not enough slack in the supply chain for the dairies. And so when the cattle don't have enough food, they stop producing milk. And so you know, that's not just a milk shortage, it's a dairy product shortage. It'd be butter, you know, everything else that comes from milk. I don't profess to know everything that comes from milk, but it'll be a bad day. And, you know, the farmers aren't going to let those heifers get skinny. They're going to slaughter them. I mean, they're going to, you know, the value of that animal at that point is the meat, and that's what they'll do. And so that would be catastrophic. It'll take longer to work its way through, but the ripple effect is big.
Thank you. And then just to also confirm, there would also be a financial impact to Reconserve if you were to have to shut down. Is that right?
Sure. Yeah. The financial impact would be large from a revenue standpoint, but also, you know, we're contractually bound to take material from those folks. So I'm sure there would be a lot of legal issue later on if we shut those bakeries down.
Thank you. And just for the record, I think the testimony in the prior hearing was approximately 112,000 per week of revenue loss. And that will conclude this witness's testimony, provided that we can incorporate the prior testimony from the hearing. But if there's further questions regarding the 6 findings, he's available for further questions.
Ms. Raccoon-Cross?
Thank you. Since the last hearing, have you looked into the food waste disposal options in California that were brought up?
No, ma'am. I am running my plant and trying to get everything together for you.
It was your testimony that the bakeries would have no place to send their food waste because it could not be disposed in landfills.
Yes, ma'am, that is my belief.
And do you recall us discussing that there is an option to put food waste in green waste disposal bins?
So food waste and green waste disposal bins from a food manufacturer. It is my understanding that the law in the state of California, signed when Governor Brown was in, that they're not allowed to throw away food waste.
Yes. And we discussed that, and you haven't looked into that in the 2 months since the last hearing?
I've not.
Is it really your contention that bakeries would stop baking product rather than look into alternative disposal options?
I'm sure that they would go that way, but that can't happen in a day. It can't happen in weeks. It would take a long time for those things, for them to recover from that.
And is it your contention that cattle farmers would kill their animals rather than look into alternative feed options?
Well, some of the farmers will do that, but that will certainly impact the price of milk because there isn't that much slack in the supply chain. You can't, the way that the world is today, everything is just in time delivery. There's not 35,000 tons of slack in that supply chain. There isn't a huge pile of corn sitting somewhere that they could feed those animals.
You estimated to receive the burner in late August, is that correct?
That's what we're told. Yes, ma'am.
And it takes 8 weeks for installation?
That's a worst case scenario. Yes, ma'am.
So why do you need until January 31st? Because by my calculations, that should be done by the end of October before your high season around the holidays.
So if things go well and it comes in at the end of August, so it will they're not sitting by waiting with a crew waiting to just come running and install it. So we have to get on their schedule to get that done. And so, it's customary for that to take at least a couple of weeks. So that's the middle of September. And then the installation, puts us, if it does go 8 weeks, that puts us into November. So and then I have to get all of the source testing done and get everything finished so that we can be in compliance again by January.
Can you set up, since you have an estimated arrival date for the equipment, can you set up the installation now in
Yeah, we're
anticipation
attempting to
of
do
the?
that. Yes, ma'am.
So you shouldn't need a few weeks after the arrival of equipment to do that setup, correct?
I don't know. I don't run their business, so I don't know how far out they schedule. I mean, I know that in many cases with other things through our experience at other facilities, a lot of times those things are scheduled out 2 or 3 months in advance. So I can't speak to that.
So you haven't reached out to them to attempt to discuss when they could
They are
come?
discussing that and they're efforting that, but I don't have an answer back.
So could you get that answer today? Could you contact them and find out? It seems like an important piece of information for this hearing.
I'll make that attempt while we're still here.
Would you be willing to commit to installing it within 8 weeks of arrival of the equipment?
Yeah, that's what I thought we'd already done that. I'm sorry. I thought that's what we had said all along, was that 8 weeks would be the maximum.
Yeah, I'm just saying as an enforceable condition.
Yes, sure. I mean, you're asking me to commit to something without knowing what can happen, because there are many things that can happen in the world. Look at the price of oil, right? It changes from week to week depending on what's going on in the Middle East. So there are many things that can happen that can impact that. If there's a delay at the port, if the people who are doing the install have somebody who is injured. I mean, there's many things that can take place that can delay that could cause you to feel that I was not being truthful with you when I'm trying to be. I don't want to say things that aren't going to be, I can't deliver on.
You testified that 8 weeks is already incorporating an allowance for those types of delays. You said that was the outer limit.
I believe that to be true.
Okay.
I believe that to be true, but then what do I say to you when it's not? That's very challenging for me. I don't want to have to come back before the board and say I made an error and I need more time.
Have you looked into other options for storage of a non-reconserved facility, an outside storage entity to deal with some of the excess product?
That's not available.
What do you mean?
So there are regulations on how you have to store the material, how you have to safeguard the material. you know, and these aren't California regulations, these are federal regulations through the Food and Drug Administration. And then there is the onerous position of having to clean after the fact. Because you have to sanitize it. You can't leave it that way.
Mhm.
There
So-
could- Go ahead.
So that's extra work, but what, you're saying there are no other facilities or other rental, you
none that
mentioned
we've ever
about rent,
found.
could you, I'm sorry, let me just finish. Renting the trucks or the things to hold it, the trailers to hold it. Have you looked into any of those other options to increase your storage so that you don't have to increase the usage of this non-compliant burner leading up to the replacement?
So I'm not sure I follow what you mean. I
You said
have.
there's
Go ahead.
Go ahead. No, go ahead.
All right,
Please
excuse me,
answer.
Excuse me,
Well,
folks.
I
Excuse
looked
me,
at-
Mr. Rudd, you guys are gonna have to, one person talk at a time. Because
My
this is very, we're trying to listen and understand. You're over talking, Riker's over talking you, et cetera. So let's allow the question to be asked and let's answer. Give a second for a pause.
Yes, sir, and I apologize for doing so. So I have looked at other options and we felt that the best option available was what we put forward in our plan.
What other options did you investigate?
So I investigated looking at Connex trailers, which I think is what you were looking at before with your comment about trucks. When you said trucks, I assumed you meant the trailers.
Yes. So why did you mentioned that as an option at the last hearing, and now you're saying that that's not an option? Is that correct?
So I'm not saying it's not, that is not an option. I'm saying, you asked me about other storage facilities. And I can't, no one will allow that.
Okay, so what about the Connex?
So basically what I'm using the Connex trailers for now, at least what my thoughts are, is that, you know, if something happens to where that, because I can't store the material outside, you know, that's illegal. And so I have to have some storage for it inside. So the Connex trailers are what I'm using as a fail safe in case everything else fails, then we would go to that option. But for the primary storage plan, the plan that I put forward is the direction that we'd like to go.
When you say it's illegal to store outside, you mean open air, like not in a container. Is that correct?
That's correct.
And so the Connex containers would be outside.
Yes, but the material is not considered outside at that point.
Okay, I'm just trying to understand. So the Connex containers, now are you affirmatively obtaining those as the fail safe, or you're just keeping that as a possibility if necessary?
We've reached out and there is the possibility that, you know, they're available for us to rent. I'm going to say it that way.
So why don't you go ahead and rent them to go ahead and accommodate that extra storage instead of requesting to run your facility more?
So what do I do if we have a problem and I have to go longer? Then I have no other option available to me for the material, and that puts us then in the shutdown of the bakeries. And so I'm trying strong to not do that. I really don't want to shut those bakeries down.
How many Connex containers can you obtain?
They've told me they can accommodate what we would need. That's the way it was put to me.
Okay. I just don't understand. So you're saying they'll give you what you need, but you're not going to do it because you might need it, but you might not need it. I'm asking if you can affirmatively go ahead and do that to accommodate the excess material. And then if you need more, you can get more Connex containers, because we're not getting exact numbers here on how many you can have, what your space is, what this the unanticipated possible issue could be that we might need more. We're trying to actually set up parameters here because you are operating a non-compliant piece of equipment right now, and you just want to continue as close to business as usual. And I'm trying to find ways to mitigate the impacts. So why don't we bring these on with an option of having more available if necessary?
So the total number of Connex trailers isn't the issue. The total amount of storage space is the issue. So I think now I understand where the disconnect is between it. So I only have so much room that I can store Connex trailers. And you can only safely go so high. And with my lots, I can only store a finite amount, which I don't have that, but I can effort that for you shortly. And then I'll have no other, if I do that up front and say, okay, I'm going to use all of my, I'll have nothing available then if something happens. Because what we're talking about doing then is not letting me run at 21.5 and staying at 18, which I think the impact of that is pretty minor as far as what the actual difference is in the emissions over the course of time. Shara can probably speak much better to that than I can, but the fact is that then we will have taken away all my options and I'll have nowhere to go but stop. And if that happens, then the things I've already testified to as far as the bakeries and the dairies will happen. And I'm trying desperately not to do that.
Have you looked into renting another location, another lot where you could put additional Connex trailers if
I've not.
necessary? You have not.
Mhm.
How are you intending, or what is your plan to reduce your storage to zero in anticipation of the shutdown if the therms are not increased?
I'm in trouble. I don't know how I can make that happen.
So your testimony is that you would not be able to comply with the 18,000 therms, or what would happen?
No, we would have material, which means that we wouldn't be as close to zero, and we would be in a difficult position as far as for the storage plan, and I looked at that closely because, we don't want to run the plant. Just to be clear about this, we don't want to run the plant more than what we need to for multiple reasons. One, because, what we're here to talk about, which is that we don't want to put any more into the air than what we absolutely have to. And further, because there's financial impact, it costs X amount of dollars to run the plant per hour. And so we don't run that plant willy-nilly. We don't just let it run, when it's not needed. I mean, it's a business. We try and be as good a steward of that business for our stockholders as possible.
You said you would be in trouble with your storage plan. Does that already include adding the Connex trailers?
No, the Connex trailers are the buffer. That's what I said earlier.
Okay, so that it would, would the Connex trailers then be part of the plan to coming down to zero, or to getting down to zero before the shutdown?
The Connex trailers are part of the plan in that if I have to, if through some extraordinary circumstance, I need additional storage, I have to have something as a backup. And without it, I'm sunk. I can't get there.
So would limiting the therms, keeping the limit at 18,000, would that be considered extraordinary circumstances? Because you said you'd be in trouble, but then you said you're not going to use the Connex trailers. So I'm trying to find out, if we keep you to that limit, would you then trigger getting the Connex trailers? Or are you saying you would still be able to get down to zero before the shutdown without the Connex trailers and the 18,000 therm limit?
So I understand what you're asking now. And the answer is, it depends on the material that comes in. I mean, it depends on the material that comes in. It depends on how quickly the installation takes place. If the installation goes off without a hitch, well, then you and I have had a lot of conversation back and forth for the last few minutes. That doesn't mean anything. That's the reality. But if it does, if there are problems, and I have to plan for those problems, I can't just assume that everything is going to go off without a hitch, because I've never seen it be that way yet. In the 36 years I've done this for a living, I've never seen them put one in that it just went smooth as silk and everything was perfect. And so I'm really concerned about, saying things that I can't deliver on. And, if I say, oh, sure, we can stay at 18,000 and we'll just use the Connex trailers. And then if we have a problem and I run out of room in Connex trailer or to store Connex trailers, then you're going to say, well, you testified that this is what you could do. And I don't want to do that. I don't want to lie or say things that aren't accurate. I'm trying to be as forthcoming as I possibly can.
I want to ask you about, I believe it's, Exhibit 6, the therm usage. Is it Exhibit 6? Which one was the therm usage? Did you not submit that as a?
No, that
Oh,
was
okay.
variance compliance.
Sorry, so this was what you submitted to the district about a week ago regarding your therms usage. Do you know which document I'm referring to? If the board would like it, I can email it to the clerk to be able to look at it.
Well, we would, but we would also like for all those documents to be uploaded so that the public is also privy.
Let me see if I can share this real quick.
The document that I have says it was originally number 2. Is that accurate, counsel? Is that what you're looking at?
This is the document you submitted to us a week ago. It shouldn't, I don't think it would be Exhibit 2. No.
Okay, so that's different than the original. That's what I was asking.
So folks, there's a request for for a break. Why don't we go ahead and why don't we break for, you said 10 minutes? 10 minutes ample time? Okay, good. All right. So we'll go ahead and we'll go off the record for 10 minutes. We'll come back on, which was allow
Okay, thank you.
use the facilities as well as gather all documents. We're off the record at 10:28 a.m.
Thank you, Mr.
No problem. No problem. All good, all good, all good.
So we're gonna be there, I'm like. I know, but if it's not safe. And then the other thing is, it's very, I feel like I used to be able to, and now I can't. So then you go here, and I go. Share bed. That's what it is now. Oh, share, share. Again, it's like share, I'm like, I just. You're your branding asset. Yeah, I just wanna spend the thing, and I feel like this is like different. Than what I feel like I used to be able to just talk, so it's very annoying, because I'll get an attachment or something, and then I open it, and then I'm like, oh, I wanna share this week, and I have to like, save as, put it in there, then open a thing. But I didn't get. No, I know, and it was totally my fault, because I was typing those, your email was right everywhere else except the one I drafted. That's totally fine. Yes, I did, yes. It should already be done. I mean. I sent it before I started my complaint section. How many pages? It's just, 2 pages. We'll forward it to Cynthia and we'll put it out on the other, which one? Oh, and then I guess we're gonna send it to Via so she can send it to her witnesses. No, they already have it.
Oh.
They submitted, well, at least I know Pete does, because he's the one that gave it to. No, somebody else did, but he should be on it. But yeah, send it to Maya, guys. I should.
for this and I love them. I said, well, we continue that would not be available, and then it
They have
says.
a broad. They go in this. But they did that for now before.
Yeah, that's it.
And it's just one page, so.
It should be.
Oh, yes. Thank you.
So, because I think it's just the way they phrased it, because it says, before this and railroad, and it's the as they would be coming into. She didn't finish that room, and I think they need that room for the finished room, but they never actually. Well, actually, there's typos that I added. That's one of the things you can tell, like, yeah, no, but there's a couple of points where it's clearly a typo and I'm like. Okay, let's see. It's not.
They will have found very.
I don't feel it because check.
I always forget it.
Right, it's 10:38 a.m. and we're back on the record. All right, Ms. Riker, the floor
Thank
is yours.
you. Before we turn to new exhibit C, which is the therms, I did just have a little bit of a follow-up on the schedule. So,
Just hold on one quick second, We're gonna log, Ms. Riker referenced it, we're gonna log a document that was proffered a few minutes ago. The Reconserve of California, Los Angeles, Inc. Weekly Therms Usage Report, raw inventory levels will be Exhibit C. Okay, Ms. Riker, the floor is
okay,
yours.
thank you so much. With asking for the end date of January 31st, that would include that high season as part of the shutdown um, uh, to do the replacement. Is that an intention that you would possibly shut down during that high season?
I won't have a choice.
Okay. Do you have any indication from the manufacturer? You said that their intention or that they've indicated to you that they would be able to get it to you by the end of August. Have they indicated if there's any, like what potentially could cause a slowdown? Is it coming from overseas?
It is coming from overseas and the potential would be the boat's delayed, there's a problem at the port. You know, those are typically the likely culprits.
Okay, but not at the manufacturing level.
It's already, as I understand it, it's already built and on its way.
I see. And okay.
They,
Um,
they.
I'm sorry?
I said they. Initially I said it, and there's two burners, so it would
Oh.
be both burners. Sorry.
Okay, thank you for that clarification. So I wanted to look at the therms usage. Do you have any more detailed information about the daily usage for June 29th and 30th?
So so you're talking about the week ending of 6/28? Is that what you're
I'm talk-
asking?
Well, I'm asking because this total here says it's for June 26th, and it's got the therms usage of 17,489, but it doesn't seem to include June 29th and June 30th if it's the week ending of 6/28. So I was trying to find out what the actual usage was for June 29th and June 30th.
So the bottom of the document shows it was for the month of June 2026 that the therm usage was 17,489. So that includes the entire month of June, as we were instructed to do.
So according to the records here, the total of 17,489 just adds up the therms used listed here, which only goes through June 28th.
So then they did not run on the last 3 days of the month.
Even though it was a Monday and a Tuesday?
Yeah. Yeah, it would be common for us to not run on a Monday.
Okay, so then on the following day, or on the following week ending 7/5, which included the July 4th holiday, which days did you run?
So I'll have to contact the local facility to be able to tell you that on exact days that they ran.
Okay, will you be able to do that and get us an answer
Yeah.
today?
Yeah,
Thank you. What is are you in charge of the Ontario facility as well?
I'm not in charge of any facility. I head the environmental health and safety programs for the company. I have intimate knowledge of those facilities because there was a time when I had operational responsibility for those plants.
Does your role, as environmental responsibility and compliance, include the Ontario facility?
Yes.
Okay. Do you want me to give you a minute to message?
Nope.
Are you done? Okay. What is the average material throughput for Ontario, either weekly or monthly?
So Ontario, on a monthly average, will average approximately 3,812 tons average.
And what is the average therm usage for the month?
I don't have that information.
Do you know what the therm limit is for Ontario? The permitted limit.
I am not aware of a therm limit. I understood that it was permitted 24/7 like Los Angeles was. I could be
Gotcha.
mistaken, but I believe it's permitted the same. There is a cap on throughput, which is just over 4,400 tons.
Gotcha. So given those limits, how are you going to be able to add additional throughput? It looks like you only have a little, like 600 tons of, a little under 600 tons of wiggle room there. Is that all that you're counting on?
So we can stretch that out over we can stretch that out over 3 months. It's in the plan to ship material there. The intention is to send them 1,080 tons. And so if we move that out over 3 months, which is what they would do, then, you know, that's roughly 300 tons a month, which would put them at 4,100. So they're still well under their permitted limit.
Is there additional outside lot space for Connex containers at the Ontario facility?
No, ma'am.
Do you feel like now you have a good handle on the Rule 1147 requirements?
I think I'm significantly better than I was the day before. I would never call myself an expert, which is why we hire Ms. Wilcox from Dine Comply.
But do you feel like you understand those requirements now?
I'm much better now than what I was. Yes, ma'am.
And have you looked into whether the Ontario facility is currently in compliance?
So we're efforting that. So with the better understanding of 1147, we're reviewing the permits, and I'm working with the local people there to assess compliance. And, you know, clearly if we discover that we're out of compliance in any area, we would be very proactive in working with the district, you know, through our council if need be, to resolve those issues.
Do you know how old the burner is at the Ontario facility?
I believe that one was late 80s and the other is mid 90s.
And are you aware that the 1147 requirements kick in when the burner turns 32?
I did not know that. No, ma'am.
Okay.
But again, we will go through that with the local people, and if we're out of compliance, we will act as quickly there as we have here.
So take more than a year to actually put in
No, that's
applications
not my
once you
intention.
find out?
The year was because we were fumbling around trying to understand what we were supposed to do. And so it should be significantly less than that if we find that we're out of compliance. But those burners are different models and different BTU values than what Los Angeles is. So there's very likely that we may not require new burners there.
Are you aware that there have been 20 complaints from the community regarding odor, alleging your facility as the source since January 2026? Or 2025, sorry.
No.
And that there's been
We've
four,
I'm sorry, go ahead.
no, go ahead if you have more to
With
finish.
my knowledge, we've had one complaint that caused the AQMD to come visit. And the inspector who did visit found that it was not accurate, that there was no odor. I mean, our plants, when we process material, it smells like cookies. We had an odor complaint where they were talking about that there was a urine smell, which was coming from the city sewer or city storm drains, where the homeless people on Beach Street behind the facility had been dumping their black water out of their RVs and campers and whatnot down the storm drain. And so that was where that odor was coming from. But we have
Are you
not,
aware? Oh, I'm
Go ahead.
sorry. Are you aware that there have been 4 odor complaints since the last variance hearing?
No, I'm not aware of that at all, and I'm not certain that the facility is aware.
And are you aware that the odors alleged are mold and old bread smells?
No, ma'am. I'm not aware of that because I'm not aware of the 4 that you're referring to.
Would somebody at your facility be aware of that?
If they've received documentation from the district, then certainly they would be. But I don't, I'm not aware that that's taken place.
One moment. Um, we have no further questions, but we would ask the witness to look into the installer's schedule and see if they can get them on calendar for after late August, as well as the throughput for the 29th and 30th, or information about when they actually operated during that week. And with that, no further questions at this time.
If I could respond to the last part of what you just asked. I received a text. They did not run the last days of the month, so the 17,000 number is accurate. They did not run past that date that month.
So-
He is looking right now to determine what they did run for July 4th, as you requested. And he's also efforting if they can give us a much better date on when they think they'll be able to start.
Okay, thank you.
Yes,
If
ma'am.
I may redirect,
yes,
thank you very
redirect, yes.
briefly. First, a couple of things. Have you received a notice of violation regarding odors at the facility, either since the last variance hearing or in the last year?
Not that I'm aware of, no, ma'am. We have not.
Thank you. I want to ask a little bit briefly about the storage, the operational considerations of storage at the facility. Is it, what I understood from your testimony, do you maintain a bit of a storage buffer in your operations such that the use of something like trailers is a last resort buffer that you would go to if needed?
That is correct. Typically, we
Okay.
try and run around 600 tons in storage, and so that gives us about 1,000 to 1,200 ton buffer back and forth. And
Okay, and so your best practice is not to essentially max out your storage and eliminate that buffer during the ordinary courses of your business.
that is correct. Yes, ma'am.
Okay, and then I also wanted to just get clarity on the question that counsel for the district posed regarding Reconserve's willingness to accept an enforceable condition that you would be able to install the burners within 8 weeks of arrival. And I guess I also want to clarify that this means, within 8 weeks of the burner's arrival on site and doesn't include source testing provisions. Is that something you would be willing to agree to?
Yes.
Okay, thank you. And I think that concludes my redirects. Thank you.
Members of the hearing board, Ms. Verdugo-Prata?
Thank you, Mr. Chair. I'm here by myself, so if my little dog barks, I apologize. Mr. Rudd, per your testimony at the last hearing, you stated that you have been the Vice President for Environmental Safety and Health for 10 and a half years for your company. Is that correct?
I've been with the company for 10 and a half years. I've been the president of environmental health and safety for the last, I think it's 6.
Okay, so for the last 6 years, which is 100% of the time that you've been out of compliance. Is that correct?
That is correct.
Okay, who do you have that reports to you in reference to let's say, for instance, like the notifications that there was a complaint regarding odors?
So the general manager, the best practice is that the general manager would uh, send that complaint to myself and the president of the company.
So you're saying that did not occur?
I have not seen anything since the last variance or prior.
Okay, and environmental safety, that, at least to me, includes air quality. Has that been your information and your responsibility
That is
for your
correct.
company?
That is
And for how many facilities?
22.
22 facilities. So those 22 facilities have, how many air districts have you been involved with?
Um, so two of them are with AQMD, so that would be the same. So 20, roughly.
20, okay. And they all have rules and regulations, maybe not to the extent of AQMD, but knowing that this is a much larger, let's say even just territory of the 4 counties, you're aware of that. Is that correct?
I am.
Okay, so it would rightly assume then that we would have more responsibility based on the, not only the territory, square miles, but also population. Does that sound right to you?
I want to correct what I said just a second ago. So I misunderstood what you were asking me. I apologize. So typically it is not broken up like it is in the state of California, where you have the district in southern, and then you have, for example, San Joaquin Valley in the north. Typically in the other states, it is statewide.
Well, don't you think that, I'm
like in
sorry, I'll let you
Indiana,
finish. I'll let you finish.
Excuse me, folks, can we allow one person to
Mhm.
talk at a
Yes.
time? Mr. Rudd, the floor is yours.
So in the state of Indiana, as an example, the Indiana Department of Environmental Management handles that for all of Indiana, not just a portion of the state.
Okay, I understand that, but our population is much greater than that state, correct? So
Understood.
it would stand to reason then that we have to be broken up based on not only the square miles in the state, but also population.
Yes, ma'am, I agree with you. And it was not criticism. It was strictly just for clarity.
I understand that, and I agree with you. However, my concern here is that you also stated you had oversight, correct?
So at
You
one
had
time. I did
oversight of
have-
environmental health and safety,
Yes,
correct? Okay.
yes, I do.
Who had oversight over Miss Shara? I'm sorry, I didn't get your last name correct. Is it Hine or Medine? I'm sorry, Shara Dine. Who has oversight over her?
So she reports to, there's a dotted with me and then the local general manager, and then she can have it dotted to the president of the company,
Okay, so
depending on the situation.
okay, so within all of you, and you're naming at least 3 people there, there was no questioning of how you were still not able to understand what was the AQMD was asking of you in reference to you had to be in compliance in reference to Rule 1147?
We didn't know we were out of compliance until the engineering group within AQMD explained that to us. We didn't understand the siloing that takes place inside the AQMD. From our perspective, based on what we.
Okay, regardless, I'm sorry, go ahead, finish. I'm
So
sorry.
from our perspective, based on how we've dealt in other states, it's the same person. So and Reclaim are the people that we have primary contact with. So when we started talking to Reclaim about the permitting, and they didn't say, no, that's not us, you need to be with engineering, then we had no idea. We didn't even realize we were out of compliance at that point until engineering told us we were.
However, you do have a permit that you have to submit every year, and you're aware of that, were you not?
And they issue us a new permit every year. I have a new permit now for 26.
Okay, okay. So between you and your consultant, neither one of you knew that you were out of compliance for 1147.
That is correct.
and I'll probably ask her when she comes up to testify, but it's just hard for me to understand if you are the VP of environmental safety, health and safety, having myself, I've dealt with large companies, refineries, as well as mom and pop shops, that even they are aware of how many rules and regs and how large the AQMD is. And even if you came into, did you come into physically? Did you meet with the engineers here at the AQMD?
No, ma'am.
It was, okay, so it was via Zoom like you are now?
It was Teams meetings and or.
Okay, all
emails.
right. Okay, well, in any case, I do have other questions. I'm going to save them for later. So thank you for that, sir.
Yes, ma'am.
All right, Mr. Palakapala.
Thank you, Mr. Chair. Morning, Mr. Red.
Good morning, sir.
Do you currently have a limit on either terms or production at your facility, the LA facility?
We do, sir. So the plant is permitted to be able to run any time of day, any day of the week, or 24 hours a day, 7 days a week. The limiting factor for us is 3,640 tons per month of throughput for Los Angeles.
3,640, okay,
Yes, sir.
all right. And you don't track terms, you just look at the tonnage, basically?
Yes, sir, that's correct. And the reason that the therms will vary from week to week or from month to month has more to do with the consistency of the material that we receive. So if we receive a lot of doughy material, which is, 50, 60, larger percentages of moisture, rather like normal bread is around 30% moisture. So, the higher percentages, we have to run slower. And so the dryer has to run more hours to process the same amount of tonnage.
Okay, understood. 3640, okay. Let me, tentatively, you expect delivery of those burners?
Yeah,
Like-
Mr. Palakapala, is your microphone on?
Yes. You expect delivery of the burners late August, is that it?
That
Or
is
when-
the latest report we have. Yes, sir. We're
So
very
how do you
excited.
prepare? Now, there is a condition in the existing variance, condition number 4. Are you familiar with that?
Yes, sir.
So what does that require you to do?
So you're talking about the petitioner shall calculate the record.
No,
Excess emissions.
maybe it's the renumbered, I'm looking at the exhibit B. The condition that says complete installation of the new burners. So it might be 5. It's probably 5, the old 5, within 30 days of receipt of the new burners.
Yes, sir. And the spirit of that was that they would begin the installation within 30 days.
It says complete installation.
Yeah.
That's something you had agreed to. Are you saying that that's not feasible?
I'm saying that that's not what I intended when I made that agreement. However, as I testified earlier, sir, if things go well, we will easily be within that number.
Right. So if you receive the burners and everything goes well, within 30 days, you can complete installation,
Yes.
correct?
That's our hope. Yes, sir.
That's a goal. Okay. So August or September timeframe, you put that, if all goes well, I mean, we're assuming it all goes well, and then you'll do the source testing and so forth after that. Okay. So how are you preparing for that end of August as far as having zero material on the floor? You basically shooting for zero material on the floor, correct?
That is correct. And if my memory serves me properly, I don't want to tell you wrong here, but my memory serves me properly, we ended last month at 617 tons. that number is going to be off a little bit because that's the end of the 28th. It doesn't account for the last 3 days. But we ended the week of 7/12 with 722 tons. So that kind of is an illustration of how it ebbs and flows as far as the income material. But we've worked diligently with the salespeople, as I said earlier, and we're trying to streamline everything else involved to lessen those dates.
So you would then you have to turn off the burners basically to install the new one, correct? You have to
Yes, sir.
shut down. So you would ask your suppliers not to send the product to you.
No, we would continue to take product. That's the diversion and storage plan that we submitted to the district. Outlines the plan itself where, we're gonna begin immediately starting to send material over rather than waiting until we're full, because again, there's no buffer. So in the beginning, we're gonna start sending material to the other facilities so that we can take as long as we can to fill our facility there. And when they reach 1,800 tons, they'll rent additional equipment in the form of like a track steer, so they can drive around on top. So then we can go up to from 1,800 to the 2,400, which is give or take a ton or two, one direction or the other, is about all it'll hold.
And when you say other facility, is that the Ontario facility you're talking about?
No, this is the Los Angeles facility I'm talking
Central
about.
facility, okay, 1,800 tons,
Yeah.
you would, okay. So let's see. So end of August, you will stop receiving throughput, you'll store the material, replace the burners, and then start operation again, correct? Depending on how long it takes.
Yes, sir. That is correct.
Actually, that's all I had. Thank you.
Yes, sir.
Any additional questions? All right, your next witness.
Thank you. I'd like to call Ms. Sharadine. Can you please introduce yourself, state your name, and spell your name for the record?
Yes, my name is Shara Dine, SHARADINE.
Thank you. And were you administered the oath today?
Yes, ma'am.
Okay, thank you very much. And did you testify at the May 27th interim variance hearing before the board?
Yes, I did testify.
Okay. And in light of your prior testimony, we will keep this very brief. But I just want to kind of revisit, where are you based, first of all?
I am out of Ohio,
Okay.
north of Columbus.
And at the last hearing, you testified that the district's way of interacting with its regulated entities was a little different from other states that you've had experience with. Could you give us just an example of that very briefly?
Yeah, and I'll back up a little bit. Earlier you had mentioned I've been working with Reconserve since 2024. I've been working with the Los Angeles facility since 2023. I was originally brought in to help them train or put together compliance programs for reclaim. All of the focus was on reclaim. So started in 2023, I've been assisting other Reconserve facilities since about 2014. They are not my only client. I service all sorts of industrial regulated entities.
Thank you. And thanks for that context. And so working in the South Coast Air District was new for you when you started working for this facility. Is that right?
Correct.
Okay. And so what's an example of how, other states may
right.
interact differently with their...
Yeah. There are a lot of, like Keith said earlier, other states have one point of contact at the agency. I'll just throw out an example for Reconserve Tennessee. They'll shoot an email right to Reconserve, letting them know, hey, this is coming up. Hey, we've got a third-party plaintiff in. Do you want to sit down and talk about it? I mean, it's here nor there. Ohio just went through a non-attainment status redesignation, and they reached out to all of the contacts about the rule change, and people that need to have a permit can do it by X date. And we learned a lot from AQMD. I'm now on, looks like about 20 email subscriptions from AQMD. And I think that should work as far as moving forward to stay apprised on rules changes.
Thank you. So have you, it sounds like since the last hearing, you've spent some time delving into the AQMD website and areas like that to
Yes.
stay to date. Okay. And since you were a primary point of contact between the district and Reconserve over the past 18 months, 2 years, was it your understanding, I think you testified in the last hearing, that you were, that the pathway forward, you were working through the air district's process to achieve compliance? Is that correct on the 1147 questions?
Oh, on the 1147, yes. A little bit of history just to recap. I started in reclaim. The focus has only been on 2012 moving forward. We submitted well, I worked with Sean Benish and I think Ryan Maxwell in the beginning, and there was even discrepancy amongst AQMD on what was happening with the reclaim regulations. You know, Sean indicated, oh, it's going to sunset, and then he'd call me back and be like, we're not sure. And there was a lot of up and down. We were working through what our current air permit said, those are limits in the current permit, which for NOx, it's 16 ppm uncorrected. And all of the stack tests that we have submitted demonstrated compliance with that. Our focus was to clean up the air permit, get rid of the bag house that's unnecessary, and transfer from a stack flow monitor to more conventional record keeping as far as natural gas usage, operating hours, different, more feasible parametric monitoring than a stack flow monitor. So we submitted all of that, had many really good conversations with AQMD. Again, worked with, I had his name, Jonathan Weldy. Sent him a really long email on this. This is what we're coming in with. What forms do I need? Do you think it's feasible? So we submitted it in December of 2024 and didn't hear back from our permit engineer until April. And that was the first time that Rule 1147 hit my radar. It's not in our current permit. I've been zoned in on 2012. So since then, especially since our last hearing, deep dive into 1147 and all of the carve out regulations that and appendices that it points to, as well as 2012.
Thank you for the recap. And so I want to revisit something that was touched upon at the last hearing. When we were talking about excess emissions last time, I know one of the things we wanted to revisit was to understand a more realistic estimate of excess emissions if the facility is granted a variance, given the limited number of operating days that actually occur. So if we could turn to petitioner 7, which is the excess emissions calculations, could you just walk us through a little bit what we talked about last time, which we talked about the air district's original calculations for excess emissions and the assumptions used there, and then kind of briefly explain the excess emissions that reflect more likely realistic operations at the facility.
Yes, yes. We have several different scenarios. Everybody there has the worksheets, I believe. We'll start with the AQMD original calculations. I was not able to find the value that they used. The original starting point is a concentration of NOx and ppm from the stack test. There was some confusion during the last hearing because I got caught up. I was zoomed in on, well, the last test we did was in 2024. So I thought maybe that's why the 39.73 ppm was not familiar to me. And then after our last hearing, I dove in, but I can't find the 39.73 number anywhere. So I'm going with what was reported in the 2021 stack test, as AQMD used 2021 stack test report values. So I'd like to change that to the 41.6 that is established in the 2021 test report. And then the other important input parameter is associated with excess emissions is the natural gas potential. I understand that AQMD used what is in the current permit. And I got to tell you, I went all the way back, which that limit is 13.36 million standard cubic foot per the dryer burner and the RTO burner, which scientifically doesn't make sense because there's a 7-to-1 ratio there. Like the dryer burner is rated at 39 million BTU per hour, and the RTO is only rated at 5 million BTU per hour. So I kind of lasered in on the natural gas usage and thought to make it more reasonable. Well, first so we'll go to our calculations, which would be like, I think your third page. I increased the initial concentration to 41.6, which matches the 2021 stack test. And I used the 18,000 therms per month because it's a current restriction. And it greatly reduced the amount of excess emissions from AQMD's 12.62 pounds of NOx per day to 0.95 pounds of NOx per day. So currently, with our current restriction on natural gas to 18,000 therms, our excess NOx emissions are calculated at 0.95 pounds per day. And then to experience different fuel usage restrictions, I ran the calculations at our worst case, which is based on recovering from, like I think, Thanksgiving, Christmas time. So our January 2026 therms were 25,185 therms. So that would be, like, to me, the highest worst case usage, just to produce realistic values for the board. And that came up to 1.33 pounds of NOx per day. And then Keith provided what he feels is a reasonable bump up from the 18,000 therms to 21,500 therms. And that resulted in 1.13 pounds of excess NOx per day.
Okay, thank you for walking us through that. And just as a point of clarification, I think the pages might have been changed on the ultimate exhibit versus what you were looking at, but nonetheless, the excess emissions calculations, as I'm understanding it, contain 4 scenarios. The AQMD original calculations, as you understand them, a worst case fuel usage based on January 2026, which was 25,185 therms, and then an 18,000 therm and a 21,500 therm scenario. Is that right?
That's correct.
Okay, thank you. Okay, that's helpful, and I think that gives an understanding of the range within which there would be excess emissions under the variance. I want to just kind of looking forward, and looking forward towards looking backwards at compliance between the interim variance hearing and today. There was a condition that required submittal of the burner application by June 30th. Was that deadline met?
It was. We actually submitted it twice. I didn't understand that the district doesn't work on Mondays, so we submitted it on June 29th, and then and Richard had the check. Richard Ontiveros had the check for the application fees and the expedite. So I resubmitted it on the 30th, and he hand delivered the check to AQMD on the 30th.
Okay, thank you. And what is your understanding of the current status of that application?
Alicia McDonald let us know that it's just preliminary complete, which means she just has the parts that she needs to move on to the next step. So that's good.
Okay. And at the last hearing, we understood that there were some, one of the original purposes of the last application was addressing some cleanup issues like a defunct bag house that has not been needed. Was that addressed in this kind of resubmittal of a new application?
No, this submittal, the June 30th submittal included an application for the dryer, the RTO, and a reclaim amendment. As far as I'm aware, AQMD never denied the bag house application that was submitted. They just can't process it because we don't have a current compliant permit, is my understanding.
Okay. And then let's see. And I think we heard from Mr. Rudd about the timeline to install the new burners, as well as working to streamline that process, particularly the source testing process. Are you involved in that at all, or will you be?
Reaching out to the stack testing company as of today, possibly tomorrow, to see if they can put together a stack testing protocol, which should be the exact same as what we just did during our last test that didn't result in a complete report. So yes, I will be pushing for the stack testing company. Their name is Alliance, to get everything ready as soon as possible so that they can submit it. I mean, they can't submit it now to AQMD, but we could submit a draft just to ensure that AQMD's testing personnel don't have any issues with it.
Okay, thank you very much. That concludes my questioning of the witness.
Ms. Rackmore-Cross?
Thank you. Good morning, Ms. Stein. Once you were informed by district staff that the source test results needed to be corrected to 3% oxygen pursuant to Rule 1147, did you go back and look at any of the previous source tests to see if those showed that you would be meeting that limit at the 3% corrected oxygen?
Oh, well, Alicia and I walked through it together because we submitted the 2024 test as as proof that we were in compliance with our air permit when we submitted the application. And she brought it to my attention, because I look at it and here's our stack test result. Here's our permit, which our permit has 16 ppm uncorrected. So Alicia brought it to my attention and she was like, no, you need to go to, page 57 that says this is where it's corrected to. And it did take me a minute to get on board. So no, AQMD let me know about the 3% correction to oxygen.
And once you discovered that, did you go back to look at any of the previous source tests to see if you had been meeting that limit at the 3% corrected oxygen?
Prior to the 2024 test?
Correct.
No.
Would that have helped you determine if you would be able to possibly meet that limit by checking to see if you had previously been able to meet that limit with the burners?
We already had the 2024 test that showed we weren't in compliance. So we moved forward with how to figure out if indeed we were out of compliance. We talked to other manufacturers, we talked to stack testing people, we tried to gather data as quickly as possible. And we were really close on meeting the testing alternative method to correct to 15% oxygen, but we're about 1% off. No, I didn't go backwards. We were moving forward.
If the previous tests had shown that you had not been meeting that 3%, would that have helped convince you that that you were in fact out of compliance and needed to put in new burners?
I didn't need to go backwards to know that we already had data that showed we were not in compliance.
So if you knew you were not in compliance, then why did you insist on testing again?
We worked exclusively and almost weekly with AQMD. After the April 2nd email that started the 1147 conversation, I needed to gather all the information. I had phone calls with Miss Shannon Lee. I had emails with Alicia, and we had Teams meetings where it was still kind of up in the air on, can we tune our burners to be in compliance? And when you're faced with, a $500,000 CapEx or, a $1,000, let's see if our burners can do this, a little engine that could, we did take our time to try and figure that out. It didn't work out. And as soon as we realized that, we did take fast action.
And when are you saying that you realized the tuning wouldn't work?
Objection. We've covered this in the prior hearing at great length, these
I-
exact
well,
questions.
Yes, but
The objection is sustained.
You mean I'm sorry, the objection is sustained.
Well, yeah, she's objecting.
I'm sorry, I thought you said the question was sustained, so I
No,
just wanted to
no, the objection,
understand.
we've gone over all of this, literally, we've gone over all of this in previous testimony, which we've included in this testimony, so go right ahead.
Yeah, the question I was originally asking, which I feel like I still hadn't gotten an answer to, was not asked, but I'll move on. Have you looked into the Ontario facilities compliance?
Currently evaluating it as we speak.
And how long does it take to evaluate whether the facility is in compliance?
We are looking at their air permit requirements. It has the 1147 language in it. They have a monthly production restriction, and they do not have any natural gas restrictions. working with the facility on the dates of the burners. Like this information is just coming into me within the last week or so. So I don't know how long it takes. I don't have all of the information yet. We have been very focused on Los Angeles.
Okay, so you've only started looking at it a week ago?
Objection, this hearing is concerning the Los Angeles
The
facility.
objection is sustained.
Can I have a moment to address the
No,
objection
no, the
though?
objection is sustained. Let's move on.
Is the part of the plan during the shutdown of the facility to send material to the Ontario facility?
Objection asked and
The
answered.
objection is sustained. The objection is sustained.
I would just like to put on the record that the Ontario facility is very much relevant here because they are intending to increase the usage of that
We
facility.
have abstained the objective. We want to
Yeah,
strike the reference. Proceed forward, please.
Yes, and I wanted to, for the record, make a point that the compliance of if we are going to rely on the Ontario facility, the compliance status of that facility is very much relevant. No further questions for this witness.
I would ask that we would be very mindful. We've literally had a hearing just 2 months ago. I believe members of the hearing board are interested in what happened from then to today. This is what we're interested in trying to understand. What happened from 2 months ago until today?
Yes.
We've literally reviewed all the documentation before us, and we're trying to get to a happy solution here that's amicable for all.
And I'm trying to establish.
Excuse me.
I thought you were done talking. I apologize.
Ma'am, please comport yourself. Thank you. Thank you. I'm not for sure what is going on today, but I've never seen so much over talking. The level of respect has gone completely out the window. We're going to proceed forward, members of the hearing board, your questions. And I want the disrespect noted for the record. Go right ahead, sir.
Okay. Ms. Stein, just on your accessibility calculation, can I ask you a few questions on that? And I think the page may have been, but this is the reconserve excess emission calculation based on proposed fuel usage of the request, 21,500 tons. Now your fuel usage, the 2.05, was that based on the requested terms or based on actual values?
If you look in the basis comment section right next to it, so 2.05 million standard cubic foot per month is just 21,500 therms converted to million standard cubic foot.
Okay, so even though you didn't get that requested amount, you still use that value?
It's just one of the 3 scenarios that we ran.
Okay, so the other, and you mentioned that because of the, there's a difference in the BTU rating between the burners for the RTO and the dryer. And so the usage varies for both of them. And so if you're using actual usage, now, if you're using do you have records of actual usage, gas usage because your gas meter is taking the total usage, right? It's not separating the dryer and the RTO.
We do have individual fuel meters. This usage, I kept it consistent with the condition number 2 of our last hearing. And the 18,000 is for the whole facility. To answer your question, I do not have individual usage right in front of me. I do know it's about 70-30. 70% the dryer burner, 30% the RTO burner.
But you have the total usage for the month.
Oh, yes. We have weekly. We've been submitting weekly usage on a monthly basis to AQMD.
Let me ask you, with the proposed request to increase the throughput, the terms from 18,000 to 21,500, we heard Ms. Grass say, what's the incremental emissions of NOx based on your calculation?
Based on, so if we go from, if you look at 21,500, that is 1.13 pounds of excess NOx per day. And if we go to, let's say the 25,185 therms, that is 1.33 pounds of excess NOx per day. So we're going 21.5, oh, that's CO. 21.5 is we're going from 1.13 to 1.33 from 21,500 therms to over 25,000. That's a
Okay.
month.
In the very last, on each of these calculations, you're dividing the daily excess by 30 days per month, but you don't operate those burners 30 days a month, correct?
No, I kept consistent with AQMD's original calculations.
Okay, all right. But that's not the daily excess emission. I mean, okay, because you don't operate 30 days a month, correct? Yeah, okay. Just one, and it's a minor, on page 8, I think it says actual NOx, but you're doing the CO calculation, I believe.
Oh, sorry.
Okay.
I don't have page numbers, but
Okay, the very last page of the calculation, it says, you're doing CO calculation, but it says actual NOx. It might have been a typo or whatever. Do you see that?
mm-mm.
Somewhere in the, where it says 971.13 pounds of NOx per million cubic feet of natural gas. But I thought you
Oh,
were doing,
yes, I'm so sorry, that's a typo.
okay, all right. So it's all, this page is all on CO.
Yes, sir, yes.
Okay. I just wanted to verify, you're out of compliance with which rule exactly? Rule 1147, which
Yes, sir.
section? Which section of the rule?
Rule 1147, I believe it's .1, table 1.
Okay.
I'm gonna let you know quickly.
You're subject to table 2, not table 1. So if I were to say it's 1147 D5, would that be representative of what you're out of compliance with?
Can you say that again? I mean, can I
Table
refer-
1, you're subject to table 2 limits, not table 1 limits. Am I correct?
Yes.
Okay, because if we're making the motion and we're referring to a rule that you're in violation of, we want to be correct in which rule you're in violation of. So that's why I'm asking that. And then, do you know what the requested, and I couldn't find this, what's the initial requested end date for the variance, for the regular variance? Was the initial request for a year?
Can I defer to counsel for that?
Sure, yes.
Yes, if I may, the petition says 12 months from the hearing date in original.
Hearing
Thank
date,
you.
Okay. And do you know with the accelerated schedule and getting the burners that you're looking at a shorter time frame, or you want to keep that same date range just to be on the safe side? And you can check with counsel to let.
It's my understanding we're going from 12 months to 8 months, but hoping for a much shorter time frame for the installation.
Okay. All right. Okay. All right. Thank you. I got no further questions.
Mr. Balakapalan, she stated that 12 months from the day. So as a hypothetical, let's say if we were to grant, the end date would be
From the date of the interim variance to under a year. to keep it under a year for the regular variance, unless, they do any criminal progress, but it doesn't appear they're asking for more than a year. So they want to keep it under a year.
Ms. Dine, you're asking for how much time?
Yes, apologies.
Very specific.
Yes, until January 31st, 2027, which is much shorter than what we anticipated asking for when we first filed the variance petition.
Okay. Any additional questions from hearing board members? Ms. Verdugo Peralta?
Thank you, Mr. Chair. Ms. Dine, you stated earlier in your testimony today that, and correct me if I'm wrong, was it April of 24 or April of 25 when you made the statement to AQMD staff, what other forms do I need? That was your statement.
Yes, that would be April of 2024, when I was working with Sean Bennett and Jonathan Waldy.
Did you get an answer to that question?
Yes, he provided me with all the forms that we needed.
Okay. Who do you normally report to, since you're a consultant?
You mean for reconserve facilities?
Yes. Yes.
Okay. I report to the general manager, Richard Ontiveros, Keith Rudd, VP EH&S, and the owner, David Lutzka. Wow.
Okay. So, and how often did you send them reports?
I'm not required to send reports.
An executive summary?
We are in constant contact because I need to work with the plant. So we have all of our emails.
But you didn't have a final report or a 6-month or an annual report to them that you were responsible for giving to them?
With each environmental project, there is a scope of work. And unless the client tells me that they need a report on a certain periodic basis, there's no such thing. It's not a given. It is, you work until the project is done.
So with this company, you didn't have any reports at all that you submitted to those 3 people that you mentioned?
I will repeat those types of reports as an environmental consultant in the scope of work with this reconserved facility. Those types of reports were not required.
Okay.
We were in constant communication.
Okay. How about in April of 24 when you were surprised that you were at the point that you were in reference to Rule 1147? Did you convey that to any of those 3 individuals?
That would be April of 2025, because we didn't submit the application until December of 2024. And all of those individuals, other than the owner, were on, I think they were copied on the email, but it was immediately forwarded to Keith Rudd for certain.
In April of 2024?
2025.
Okay, I'm asking you about when you had the conversation with the AQMD staff that you were surprised, and that's when you started doing the deep dive on 1147, that you were surprised. When did you convey that shock to your the company? Either of those 3 individuals that you mentioned. Did you?
That day, April 2nd, 2025.
No. Okay, I think we're getting confused here. I'm asking you specifically about April of 2024 when you stated you were surprised that you were out of compliance. Unless I've got it wrong, when did you realize you were out of compliance? April of 2024 or April of 2025?
I do think there's a misunderstanding. So in April of 2024, I was working with Ryan Maxwell and Sean Bennett on what types of application forms we would need to submit to amend our reclaim permit. And so they helped me with that. And then the shock and awe came with April 2025 email from Alicia McDonough indicating Rule 1147 had some compliance issues.
Okay, so prior to that, there was no discussion of 1147 with anybody at the AQMD.
No, ma'am.
Okay, thank you.
Any additional questions?
No.
All right, thank you. Ms. Rucker, your witness, or Ms. Rucker, yeah, we're gonna dismiss Ms. Dine, and we're moving on to Ms. Rucker.
Yes. The district calls Alicia McDonough. Please state and spell your name for the record.
Good morning, members of the board. My name is Alicia McDonough, spelled ALISHA
And did you take the oath this morning?
I did.
And what is your position here at the district?
I am an air quality engineer 2 on the chemical team.
Thank you. Since the last hearing, have you looked into the compliance status of the Ontario facility?
Yes,
This is a hearing concerning the LA facility.
Okay, may I establish some foundation here for the relevancy?
Yes.
Ms. McDonough, taking a step back, did you hear the testimony of Mr. Rudd? Is that his name?
yes,
Mr. Rudd, that the LA Reconserve facility intends to utilize the Ontario facility for some of the material that would normally be put in, used or processed at the LA facility.
I did. That led me to look at their permit there to see what the throughput was for that facility as well.
And did you review the document that was required to be submitted under the previous variance condition number 12, the Reconserve of Los Angeles Diversion and Storage Plan during burner replacement?
I did.
And did that document also indicate that they would be utilizing the Ontario facility for storage and processing of excess material?
It did.
Thank you. And when you looked into the compliance of the Ontario facility, what did you discover?
I looked at the dryer and the RTO to see if they have fuel limits or throughput limits, and then I saw their NOx limits, and the RTO has a limit of 30 ppm, and based on its age, as of July 1st of this year, it should be meeting table 2.
So would that require a new permit application?
It would.
And when would that permit application have been due?
It would be due July 1st of the year that the burners turn 32, which according to the records I have access to is this year for the RTO.
So do you have concerns about the compliance status of the RTO dryer at the Ontario facility?
For the RTO, yes.
Okay, thank you. No further questions.
Ms. Gross?
Thank you. And so in your review, let me back up first of all. The RTO is currently in compliance. Is that correct?
It is not my belief that is in compliance currently.
Okay. And are you aware of any notice of violation that has been issued in this regard?
No.
Okay. I'd like to also go back to odor complaints that were referenced earlier. Did you review any odor complaints related to the LA facility?
Yes.
And can you explain to me the Air District's process for receiving and investigating odor complaints?
That's outside of the purview of my job. I'm not 100% sure of exactly what the inspector's policy or procedure is, but I can see their reports for when
Okay.
they were called and what odors they found and who they contacted.
Okay. So do you know if these odors have been verified?
Yes.
And do you know if they resulted in any enforcement action?
Not that I see, no.
Is there a process at the Air District for verifying odors or having a specific number of odors before enforcement action is taken?
Objection, she just testified she's not aware of those procedures. It's outside her purview.
Overruled.
I am not aware of the exact procedures of compliance and the number of odor complaints that they require before issuing notification.
Are you aware at all that they require a certain number of odor complaints, even if you're not aware of the specific number?
Objection, asked and answered.
Overruled.
It's my understanding it usually takes more than one. Yes.
Does the Air District keep a log of the disposition of odor complaints when it investigates the complaints?
Do you mean like a status?
Yes. What do they track the status of an odor complaint investigation?
Yes.
Okay. And do you know how these complaints, what the disposition of them were?
It's in the chart that I have, there's different dispositions for a number of them. I'm not aware of what all the different dispositions mean. They're abbreviations.
Okay. No further questions.
Members of the hearing board.
Ms. McDonald, I think you're still in the morning session. You've seen the calculation submitted by Reconserve, using the same methodology that the district provided.
Yes, sir.
And do you agree with how they have done the calculation?
Preliminarily, yes. I took a look at it this morning. Yes.
So they didn't take, I believe, I mean, we had this discussion the last time. The district had double the usage based on the same amount of fuel for the RTO and the dryer, right?
As is allowed in the permit. Yes.
As allowed in the permit, okay. But if you take actual, it might be different.
Yes.
Okay, so the actual emission may be different. So, okay. And would you also agree that to get daily excess emissions, you shouldn't be dividing by 30 because they don't operate 30 days a month?
I would say it just depends if you want a 30-day average or if you want a maximum daily emissions excess. Those are just two different.
Look at 30-day average, correct?
I'm sorry, can you repeat?
The 30-day average is normally used for offsite purposes, correct?
That's correct.
Okay, all right. Not for excess emission. In the rule for excess emission, it doesn't say daily maximum per day, right?
I'm not sure.
Not sure. Okay. I don't see a condition in the order here for the Ontario facility or the report, that they're supposed to submit to about where they shipping it to Ontario, what they're going to do with the waste and how they're going to handle it. There's no condition related.
That was the previous condition, but it's been fulfilled, so it was removed from this version.
Okay.
Yeah.
All right.
I can speak to that if you prefer of what the report said to us.
No, I'm looking at the current, and the relevance of Ontario facility to this order in this facility. Okay. Let me ask you, the condition number 3, you have concentration limits for NOx and CO, and this is based on the combined, right? Calculate, how much they shouldn't exceed the 39.73 is based on the combined flow.
That's correct.
Correct. So should the condition 10 then says, NOx emission in pounds above 30, but should it be above 39.73 then instead? And the same thing for CO.
For condition number 10, it could be the combined limit.
Combined limit, okay.
That would be, for this case, 28.8 based on the
28.8,
difference.
Okay. And what's for CO?
CO, they're both 1,000, so it would just be 1,000 ppm.
Okay, 1,000. The combined, okay.
Yes.
All right. 30, 28, okay, 28.8. All right, okay. That's all I have. No further questions. Thank you.
Thank you.
Any additional questions from members of the hearing board? All right, we're going to move to closing. Ms. Cross?
Thank you, Chair and members of the hearing board. Reconserve greatly appreciates your consideration of what amounts to about 8 hours, at least, of testimony in this matter, much of which was heard at the last variance hearing. But I think you have heard sufficient testimony in that time to be able to make the 6 findings required for a regular variance. Particularly unique here is that this is beyond their reasonable control to comply, because the key word there is reasonable. And as we heard previously, there were extensive, long-standing contacts between Reconserve and the Air District, particularly in the context of their reclaim compliance, both with reissuance of permits every year under reclaim, submittal of emissions reports, submittal of source tests under reclaim, inspections at the facility under reclaim. And throughout all of that, if there were issues ever in compliance or questions, Reconserve was informed of that by the district. And those have been sorted out. And they were, they proceeded, and they've been operating under that understanding. As you can see, this is an unusual situation where they had these extensive contacts, and then they went to do a permitting exercise and interacted with different staff, but didn't really understand the nature of how the district works, which we've seen here even today, that sometimes the staff can be siloed from one division to another. And when you're coming from outside of the state, where you've worked in a lot of different statewide air agencies, and that's not the case, I think it was perfectly reasonable for Reconserve to proceed in their interactions with the district as they did. At no time were they trying to delay or being difficult or hide the ball. You heard testimony to that effect. You also heard testimony at the last hearing about how there was an earnest misunderstanding about the district's role when it interacted with Reconserve, how it didn't feel like it could talk about the variance process because that was legal's role or similar. But Reconserve didn't know that at the time, because they would hear some things like, these are ways forward. You can appeal the permit before the hearing board, but never heard anything about the variance process. But they didn't know they weren't getting the whole picture. They thought they were working collaboratively with the district. And they've always maintained that approach with the district. They know now very well how the district works. And as they continue to move forward with their facilities within the district, they will proceed accordingly. But it was absolutely reasonable for them to have proceeded the way they did. And as you heard in the last hearing, they thought they were following the AQMD's process, getting from an understanding of perhaps there's an 1147 compliance issue to how do we get to full compliance. They didn't understand that the process was not meeting and resource testing, because the AQMD staff seemed amenable to that at the time. So again, I think we can make the findings here through the testimony that you've heard that it was beyond their reasonable control, and that now that they know what they know, they will be interacting with the Air District accordingly. And this is a unique circumstance here. These facts are very unique, and they're not something that I think has come before the board frequently. I also want to touch on the harm. We've heard harm to the employees, harm to Reconserve if they have to shut the facility down, and the ripple effects in the affected industries. We've also heard testimony about curtailment that was considered, and in fact, they're operating under a curtailment provision. And I also just want to touch a little bit on what has happened between the interim variance and the regular variance hearing, and that's continued proactive interaction by Reconserve with the Air District in the submittal of the application, as well as follow-up on the application, and an intent to continue to do so. On the odor complaints, you heard testimony that there has not been an NOV or any enforcement action taken on odor complaints, and that there are different dispositions for odor complaints that have been investigated by the district. So I think it's very telling that these are brought up, but there's no basis to them. So that was a little bit of a cheap shot, I think, by the district that did not really serve any sort of purpose in the hearing board process here. And finally, I would just like to say that Reconserve is dedicated, I think, as it shows already, to achieving compliance as quickly as possible. And they have been following up with the burner manufacturer and working to streamline and align the processes for source testing, scheduling source testing, and working to get to compliance at a date much earlier than previously requested. That date being January 31st, which builds in a buffer to work around any busy times. But the expectation, as you heard, is that the full compliance will be achieved much sooner than that. And finally, I want to touch on excess emissions because you heard a more realistic picture of excess emissions from Ms. Dine, and that under the proposed conditions of 21,500 therms, it's only 1.13 pounds of NOx per day, which on a monthly basis is also just 34 pounds per month of excess potential NOx under that. And just to compare, the district's calculations are an order of magnitude higher. So I think it's more reflective to have approximately 34 pounds per month of excess NOx emissions were this variance to be granted. Finally, I think you heard that Reconserve has been complying with the conditions and looks to continue to comply with the conditions during the variance period. And again, I appreciate the board's patience and consideration of these many hours of testimony. Thank you.
Thank you, Ms. Rack.
Thank you. Just as a administrative matter, I did just want to, for the record, correct the word interim on Exhibit B. It should say regular variance conditions, which I know we've addressed. I just want to make sure that's on the record. The district is opposed to the granting of this variance, as has been discussed. This facility was on affirmative notice from district staff beginning in April of 2025 that they were out of compliance, and yet they delayed and attempted to find workarounds and exemptions that district staff informed them were not applicable, and yet they just insisted on continuing down that route. Whereas if they had taken immediate action when they were first notified, they would have long been in compliance. The facility continues to assert ignorance of the regulations, but it is longstanding legal precedent that ignorance of the law is no excuse. Violations of the Health and Safety Code and AQMD regulations are assessed on a strict liability basis. And this facility is no different. This board has repeatedly found that just failing to meet a deadline without additional considerations is not sufficient. Having a environmental and compliance manager or a consultant that is not familiar with AQMD regulations is not an excuse. It is not beyond their reasonable control to ensure that they have consultants and employees that are familiar with the requirements. They are a reclaim facility. They are not a small mom and pop facility. They should have been aware, and they just affirmatively did not take the actions to ensure that they could be in compliance. We also heard excuses of things being too hard. Getting alternative storage options is too hard. They haven't looked into finding potentially other lots to use these Connex containers. They're not affirmatively bringing the Connex containers because they just want to hold that in reserve, whereas that would allow them to maintain a lower therm output and potentially not rely on a facility that they have failed to look into to determine if they're in compliance. And it appears, based on our preliminary examination, that a new permit should have been submitted by July 1st, and it was not. So that is additional evidence that this facility continues to scoff at the district's rules and not take action to come into compliance. To briefly address the district's role, the district is not a consultant for any facility, including Reconserve. AQMD staff will not tell a facility that they cannot attempt options to come into compliance, but that does not excuse that facility from the ongoing noncompliance when those efforts fail. The issue here is diligence is acting quickly and assertively to come into compliance, and that was not done. In September 2025, this was when the tuning was brought up. Again, that was many, many months before they ended up coming before this board, and they did not do so in a timely fashion. This hearing board is case number, or this case is hearing board case number 2876-8. The facility has been before this board 7 times before. They should have known about the availability of this relief, and they, for whatever reason, did not take advantage of that. Finally, shutting down is not the only option. The district has attested to at the previous hearing and again remains willing to work with the facility on a stipulated order for abatement, which is the appropriate mechanism when a facility is out of compliance and does not meet the requirements for a variance. For these reasons, the district is opposed to the granting of this variance.
Mr. Pearman.
I was somewhat reluctant at the interim variance stage, but agreed to the interim variance. I think as the chair said, been looking to see if anything has happened since then that would have made that decision incorrect. I've seen nothing. Looking to see if there's anything that contradicted the testimony before. I've seen nothing. Look for anything that since then the air quality has worsened. I've seen nothing. Apparently the idea about odor violations was a red herring. And so I think whatever reservation I had, that ship has sailed. And so let's just have them proceed with the variance in accordance with appropriate conditions. And I'll just listen to my fellow board members to see whether they want to adopt the proposed conditions by the party or make their own amendments.
Mr. Balakapalan.
So I agree with Mr. Pearman. I think the diligence filing and everything, it was addressed during the interim variance. The board did find the 6 findings to grant the interim variance and good cause and the interim variance. The good news is that they have been aggressive in trying to come up with a solution. Clearly, they're in violation. There's no question about it. They are in violation of 1147 NOx and CO limits. So that's there's no question about that. And so they need to come into compliance. But they have taken appropriate measures to come into compliance sooner than initially they thought. You know, they were going to initially request it for a year, but it looks like they only requested it till January 31st, 2027. So that's a good news in the sense that they can come into compliance sooner and reduce their emissions, hopefully with the new burners. And I also, looking at the excess emission calculation, what Ms. Dine has done, I think I'm more inclined to follow hers than the worst case that the district did. And so the incremental emissions is very little. Even if you don't divide it by 30 days, I roughly get about 2 days a day and about 17 pounds for NOx and about 17 pounds of CO if they did like 22 days per month. So going from, I know Mr. Pearman, maybe, I have no problem in going up, you had come up with a figure of 18,000, but I think the requested amount 21,500, the incremental is not much different. So I'm okay with approving that higher throughput request so they can get this product clean out of the way and get ready for the burner replacement so that they can come into compliance as soon as possible. So I do believe I can make the 6 findings to grant the regular variance and I can go through that at the appropriate time or before I make the motion, or if somebody else want to do it.
Well, I was just going to incorporate it in if we were going to go down that road, but Ms. Peralta, Verdugo-Peralta, the floor is yours.
Thank you, Mr. Chair. I do not agree that we should grant them this variance. Rules are rules. They're there for a reason, and they're there to try to keep the air clean. They've been out of compliance for 6 years, and we're going to add another one to that. The fact that Mr. Red claimed that he was the oversight, and he did so for 6 years and was out of compliance the 100% of that time. In all of the discussions with the AQMD staff, I don't understand how they would not have even asked the question. Well, what about this rule? We also have this rule to consider. Every time that I have had that role and gone with the company to the AQMD, it's always been, and what else is there on the table? What else do we need to be worried about? You know, I'm very reluctant to grant this at all. I agree that they did not do their due diligence. They had a lot of time to do it, and they took even another year from April of 24 through this year. It's just beyond me how we can go ahead and let any company do this for this long. You know, this is supposed to be where the rubber meets the road and where we decide, okay, we're adding to the emissions. This basin is already overloaded with all of the toxic emissions that are there. Adding to the bigger bowl of soup, to me, is not the right answer at all. Thank you.
Any additional comments?
Sure, Dr. Abraham here. I'll chime in. I am feeling torn between both sides. I appreciate all of the perspectives of my fellow board members. I too am concerned in several of the answers that we received from the petitioners, witnesses, and do feel that we have given a lot of allowance, and I do expect more, not only due diligence, but seeking out either resources or answers to questions if we're not clear of the rules. And I do expect that the petitioner make sure that they have adequate counsel or consulting or advice in order to comply with our district rules. I do feel, though, however, that if the district feels so strongly that the district should consider proceeding with an order of abatement, if that is the appropriate route, I don't know that denying this variance achieves that end either. So this is definitely a tough decision. I do feel between the last hearing and this one, to some of the fellow board members' comments, the harm to the public and the environment, while minimal and while notice of violations were negligent or insignificant in this period, I do feel that we're creating a pattern for them that they can come and seek the variance in the 11th hour and claim perhaps ignorance or naivete. So with that, I'm still torn at this time.
All right, thank you. I move that the hearing board grant a regular variance in case number 2876-8 to petitioner Reconserve of California, Los Angeles, Inc., facility ID number 20203 from South Coast AQMD rules 203, 1147, and 2004. The variance will remain in effect until January 31st, 2027. This motion incorporates all oral testimony, declarations, and written evidence presented during the interim variance hearing on May 27, 2026, as part of the official evidentiary record supporting the necessary statutory findings. Based upon this record, I move that the hearing board make the 6 necessary statutory findings required under Health and Safety Code 42352 and South Coast AQMD Rule 515A. The regular variance for case number 2876-8 and facility ID number 20203 is granted subject to the conditions articulated in Exhibit B, which are incorporated herein by reference. Is there a second to the motion?
I was more referring to the difference between B and 8 from the petitioner was the throughput, and I think I have no objections with the increasing from 18,000 to 21,000. So is it an Exhibit 8? Is it a B? 8 from the petitioner.
Okay, all right.
And with the change to condition number 10, that the limit be changed, 10B, the NOx in pounds above 39.73 ppm, Oh, no, it's 28, I'm sorry, 28.8, yeah.
28.8.
28.8,
28.8.
and, but that change.
Madam Clerk, did you record those?
I got condition number 10, with change to NOx to 28.
28.8, sorry.
28. And then in corporate, are we using,
We're gonna use Exhibit B as well as Exhibit.
No, I'm sorry, Exhibit 8,
eight?
8 from the
Exhibit
petition.
8 and B.
And I just add approximately the excess emissions are roughly, I have the calculation. Previously we had, in the interim variance, we had between, I think, what was the number there? 12.6 pounds per day of NOx and 162 pounds of CO. I don't believe it's that high, based on the information submitted. I would say it's about ranges about 2 pounds per day of excess emission of NOx and about 17 pounds per day of CO. But then it's subject to verification.
Okay, Madam Clerk, did we capture that?
And in corporate, 21,000 per month.
21,500.
Yeah, thank you so much.
All right, is there a second to the motion inclusive of the amendments?
I'll second it.
Mr. Balakapalan seconds, Ali moved. Any further question or discussion on that motion? Hearing none, Dr. Abraham?
Aye.
Hugo Prouter,
No.
Mr. Balakapalan,
Aye.
Mr. Pearman?
Aye.
Ali votes in the affirmative. The matters hereby approved 4-1. Thank you very kindly for today's time. We do have one more item. We're going to go ahead and dismiss the individuals involved in case number 2876-8. Yes, we're going to take, how much time do we need? Okay, we'll off the record for 10 minutes and then we'll get the attorney on the Zoom off the record for 10 minutes.
Come here, puppy.
record at 12:26. We're back on the record at 12:26 PM. A matter that is before the hearing board is located under the section titled Other Business. Proposed administrative amendment to Rule 4B4 of the Rules and Procedures of the South Coast AQMD Hearing Board. This is merely a cleanup item. I'm going to turn the floor over to Mr. Larson, who can provide some further context.
Thank you, Mr. Chair. Good afternoon, members of the hearing board. So the context here is that last year, the hearing board considered and then voted on and adopted a new rule, which was codified as Rule 4C for handling items that are placed on the consent calendar. And one of the things that new rule did was allow any member of the hearing board to request to the chair that an item be taken off the consent calendar if they want to ask more substantive questions or something along those lines. And that was adopted. We just noticed in doing a review of the policies, there's a remnant of the old way of doing things in 4B4, which still says a individual hearing board member can take an item off consent calendar. And so to avoid confusion, our recommendation is that you adopt this cleanup, strike that one phrase to be consistent with what the board adopted last year.
All right, Mr. Balakapalan.
Mr. Larson, I'm confused though. There are two separate issues here. On the procedure, the one that was adopted the last time was before the case is heard on consent, the board members could submit in writing their reasons for not having it on consent, and the chair could overrule that. That's for before it's put on the calendar. This particular portion is also on during the hearing, also about the petitioner or the respondent or a member of the public could ask for it to be removed, and also a chair, a hearing board member. So there are two different operations here. I think if you're trying to, I know what we adopted was the chair can override before it's put on the consent calendar. But once it's on the consent calendar and we have a hearing, that's it's a separate issue. If you want to take away the right of the board member, which was taken away the last time, to have a hearing with the parties present, and this is taking away, even further eroding the, what's the purpose of me being here on the board if I can't raise some substantive issues and get it addressed? I bring, the 5 members of the board, the Health and Safety Code specifically selected the different types of members should be on the board so they can bring their background, their knowledge to the process. And then it's like the whole thing is negated because a chairperson, and I'm not picking on the chair per se, but the chair who may or may not understand the whole issue is saying, nope, I want this because it's more efficient where we have it on, or more streamlined if it's on consent, and take it off consent calendar without, I may add, without a reason. When I put in my reasons for not having a consent hearing, I list them. I list the question, I list the reasons why. When it's taken off consent, there's no response or nothing in the record why the chair took it off consent. That's one issue, we have. So, but what I want to point out is maybe the numbering should be different. If the intent is to do this is a different issue. It says decides at a hearing. That's already, different. So there's a hearing, and then on a consent item, which has been taken off calendar. But let's say, and I'll bring not a hypothetical. In a way, it is hypothetical. We had just without naming the facility, we had an item that I objected to being on consent, but the chair overruled it was on consent. And then, and we heard it it wasn't a consent hearing. because the party, well, they were not here for me to ask any questions, even though they responded to all the issues I had. I had like maybe 15 different items there. But nevertheless, if, let's say that was decided on Friday or whatever, and then the hearings on Wednesday, in between, and this happened, there was something in the news regarding that facility. And so a board member or somebody could raise, hey, look, I've heard this, maybe it's relevant, maybe we should get it addressed. And that's, I think, is what this is referring to, this section where at a hearing. So this is not a consent hearing, but I mean, it is a consent, not a consent hearing because it's been taken off consent, but it's a hearing where a board member has raised an additional issue which may have not been thought of when it was, whether they agreed to hear it on consent or not. So I like your thoughts on that. Why are we conflating the two like this?
But that's a good question. So the 4C that you all adopted last year has a subsection 4, which pertains to request at a hearing. So let me just read that and see if this alleviates your concern. So 4C4 reads, which is now part of your policies. If a board member decides at a hearing for which a matter has been placed on the consent calendar that he or she has substantive questions relating to that matter, or that he or she wishes to make substantive changes to a proposed order or conditions for that matter, then the board member may request to the chair or the chair's designee at the hearing that the matter be rescheduled for a later date and not heard as part of the consent calendar. The chair or the chair's designee shall have the discretion to move the item or to keep the item on the consent calendar. And so, that was meant to address, I believe, the situation you're describing about if something happens and you get to the hearing and a board member at that time still has a concern, can then make the request. And I still think striking the unilateral hearing board member authority from 4B4 would be consistent with what you adopted in 4C4.
And I think that's where the error, if I may point out, happened. It should have been 4B4, maybe it should have been 4B3 or something where it says the chair can, because that's 4.3 is where you disagree and that the chair is overriding it, then it should have stated there. For C4 is, it's a different scenario, basically. It's not the same.
Mm-hmm.
That's what I'm trying to point out there,
All right, Mr. Abraham, Dr. Abraham?
Yeah, no, I appreciate that, Mr. Larson. But so, Mohan, I guess in that scenario, I don't quite understand. So if we already decided it was consent and now we're all in person and we're taking the vote, and let's say a hearing board member disagrees, at this point, neither party is present in the room. So what would be the workflow, or how would that be operationalized to take something off of consent calendar if there's no one present in the room to ask questions to? Are you saying that we would just have to reschedule the hearing, or I just don't see how this rule eliminating actually allows us to address the issue of allowing one hearing board member to take something off consent ultimately.
Yeah, that's what it says there. You may request the chair or the chair designee to reschedule it because some other issue has come up, and not be heard as part of the consent calendar. So the language is, is requesting that. Now the board may say, no, we don't need to do that, and decide that. But
do you feel, though, Mohan, that by removing this rule, that ability for a board member to ask the chair to reschedule due to new information is not allowed as a result of removing this rule?
By changing it where it is, yes. And I think it's probably, the majority voted to have the chair, give the chair the mandate to overrule any board member, and so that's fine. But I think then it probably appropriately should be under 4C3, I think, and because that's a scenario that pertains it, because you've submitted your request and the reasons why it shouldn't be on consent, and the chair said, okay, no, I disagree, and so that's fine. That's what was decided by the majority. While I disagreed with it, that's what it is. But I think this portion is a little different, I think, because this is now at a hearing, even though it's on a consent. It allows the petitioner or the respondent to come to the hearing and make a request to reschedule it, and a member of the public too. but why take away the right of a hearing board member? The majority can decide and say, no, we disagree, and that's it. But at least you can bring it up, you know.
Ms. Verdugo Peralta.
Thank you, Mr. Chair. Hello, Mr. Larson. Nice to see you.
You too, thank you.
I agree with Mohan that this really dilutes the expertise of us as individuals. We have, there's a reason that there's an engineer, there's a reason that there's an attorney, physician, and then members of the public. It to me also, and I'm speaking as a former chair, I think it gives too much power to that chair to be able to do that. I overall, and I'm looking at this past year, I personally think that we need to have more hearings versus not. I think we go to consent quite a bit, and I don't think the public has the opportunity to hear really what's affecting them within their neighborhood, within their county. Yes, they can go and they can take a look at it, and if they're really concerned, they might even show up. But we know that that's not always the case. And they rely on us, five, to be able to do that on their behalf. And I'm just really concerned that we're going down a slippery slope here that is not in the best interest of the public.
Chair Ali, can I ask a question of Ms. Cynthia?
Go right ahead.
So, but alternatively, wouldn't the flip side of that be that you could have hearing board members that consistently pull everything off of consent, and then now we're no longer, the public is also trusting us to get the people's business done efficiently and effectively and mindful of the limited resources of the office of the clerk of the board, and as well as the AQMD staff, as well as unnecessary calling in petitioners or the business owners or this, that, or the other. So I feel like somebody's going to ultimately have the upper hand. Wouldn't you prefer it to be your chair rather than having a member be able to unilaterally dissent and hold every case hostage, which could ultimately also happen, which I do feel would be a disservice to the public and the district.
I agree with you on that point, but that's not happening, is it? We're not taking every single case and listening to every single case, nor did that happen when I was chair either. There were appropriate times when consent was the right thing to do, especially when everybody agreed and there was no real outstanding public concern and or danger to the public. And I'm not saying that that has happened either. I'm not saying that the chair would ignore that. I'm just saying that it gives too much authority, too much power to that one person who doesn't necessarily have the legal expertise or the engineering expertise or knowledge of the rules enough to the point that it's not going to, the pendulum is hopefully going to be in the middle, not swing one way and not swing the other, so that it makes sense that, it's going to go on to consent because of the fact that, yes, it'll save everybody time. But then again, why are we even on this board? We're on this board to speak up and to go through the issues that a company is out of compliance or whatever the case may be, and we need to discuss it and be aware of what the consequences can be to the surrounding area.
Can I add? Sorry.
Go right ahead, Balaka Palanda. We're here, Pyramid.
Yeah, I think I brought this up before. The Bay Area actually has a language very pertaining to this. The hearing board will not include any matter on the consent calendar that involves emission of toxics, undue harm to the public health, or other potential nuisance. So they've established certain standards for what, should or should not be on consent. And I believe, and like Ms. Verdugo Peralta said, there are many cases that can easily go on consent. I mean, but if we're going to do this, continue to do this, and why should I bother saying no and putting my questions and spend time asking all those questions, and then find it's completely been overridden. And a lot of times I find there are mistakes, and I correct it, send it to them, and they correct it, and then I agree to put it on consent. In the future, I might just say no to consent, and then during the hearing, I'll bring up those points why I objected to it and put it on the record. Why the board shouldn't adopt it. And the doctor's right. At that point, the parties are not here to respond to it, and so that's not fair to them either. There is a place for consent calendar, no question about it. And it streamlines it, especially when you have an interim and it comes again to the regular. It's all been resolved. It's just a formality to go through. But here, sometimes, when we have a landfill with public complaints and, certain scenarios, a toxic emission source, and putting it on consent because it's convenient, and because, quote, the district and the parties have both stipulated to it, just because they've stipulated to it doesn't mean that a board member cannot raise the issue and have an open discussion where we can ask questions, before, just we could have, let's take this case here, to put this on, we could have had just a vote. Why even bother having Mr. Larson here? We have the document and say, okay, it's here, go ahead and vote on it and you're done, But having Mr. Larson here, we can ask him questions and he can explain and clarify, why it should be this way or not, But so there is value, I'm saying, sometimes in having the parties here to ask questions, and so you can find out and get more information. Another example, just recently we had an order of abatement that was not contested. And when we had the question of the owner of the spray booth, we found that the district had mischaracterized what is going on there. But we found that out because the parties were here and we could ask the question. So you can say, oh, the document is there, everything is fine. We should just go ahead and rubber stamp it. Basically, that's what I'm seeing. We seem to be rubber stamping a lot of this without having a substantive discussion on that issues. And here, another point I want to bring up, there is the rule is very clear also when you should file for a consent. Frequently, we find that the parties don't follow that. They file it on a Thursday at 3 o'clock, knowing a couple of cases, the holiday, it was a holiday on Friday, or the board doesn't work on Friday, or they may be closed on Tuesday, and the hearing's on Wednesday. That doesn't give any time to respond and for the, to get it posted and also to respond, basically. We don't work on Fridays, the rules are very clear when they should file, the timeline they should file. We had a case recently, they didn't meet the timeline, but we went ahead and accepted a consent, heard it on consent when it shouldn't have been, because they clearly violated the other portion of the rule on the consent, which is on hearing board rule that says when you should file,
Okay, you done? So
I'm done, sorry.
Mr.
Yeah.
Perman, the floor is yours, sir.
Yeah, I'm looking at this agenda item, and so much of the conversation is kind of irrelevant. We agreed some time ago to modify our rules, and they eliminated, as Dr. Abraham said, the ability of one member to unilaterally hijack the calendar by pulling things, but create a reasonable procedure to handle that. And so let's see how that works out before we rush to change it. So all we have before us is agenda item, and since the current language said that one member shall be able to pull, we have to fix it to be consistent with what we ruled. Oops.
Just one last
We
comment.
lost you visually. Hold on, so I'll make sure that.
Hold on 1 second. We've lost visual
we were
contact.
heard.
Yeah, I also had just one question or comment.
Hold on.
Well, we're gonna go,
Who did we lose?
Perman is on the floor. Hold on 1 second, folks. We're trying to gain visual connection.
They lost their screen.
Mr. Larson, are you sharing the document?
No, I believe the clerk is sharing the document. For what it's worth, well,
There we
now the
go.
document just got
Okay, there we go. We're good now. Mr. Perman has the floor.
Oh, I was just finishing to say that, again, as Dr. Abrams said, we made a change already to prevent the unilateral hijacking of the consent calendar by one member. And so let's see how it works. So this change, again, the only item before us is simply to fix the rule that would have negated what we've already done. And we have to remove the language that says that our hearing board members shall be able to pull the matter. So all this other discussion to me has been resolved, and let's see how the new procedure we adopted works out for a while.
Very well. Dr. Abraham.
Yeah, I would just add that there are so many instances where we are not able to use consent, whether it is those interim or some of those more emergent issues. Clearly, like today, when the district did not agree that, you know, one of the parties disagreed and it was not heard on consent, there are many avenues where we are going to end up with hearings. This, I do feel like, is narrow. This is to make sure our rules are consistent. And we're in almost like this test or pilot. And at some point, I think to the issues that, you know, Ms. Verdugo Peralta raised, that Mr. Balagopalan have raised, I mean, then those are things that we can revisit, whether the chair should have the prerogative to proceed with consent and change that rule again. But I think for all the reasons that have been previously stated, and truly believing that we are moving efficiently, but also effectively, and that the district does pull the cases that they don't feel comfortable moving with consent, and that there are, especially in those emergency situations where we know we need to make sure we hear things carefully, I think there are a lot of guardrails to keep us proceeding appropriately and transparently. And so I would support this rule change.
All right, Ms. Verdugo Peralta.
To Mr. Pearman's point, yes, we voted on this a year ago, but we've also had a year to see how it's working. And I, for one, don't feel that it's working as well as we were hoping that it would. I agree with Mr. Balagopalan's statement, unfortunately, that too many times it seems that we are rubber stamping something that should have been brought to light and should have been discussed in the light of the public. And so that the public was made aware of not only the problem and the situation, but that they were going to be affected by it. And that's my biggest concern, is that they are unaware that they're going to be affected by it. They have no clue that they're going to be affected by it unless we have a hearing about it. So
Thank you. I want to lay a motion on the floor. I
Can
move
I-
that the hearing board approve and adopt the proposed administrative amendment to Rule 4B4 of the Rules and Procedures of the Southwest AQMD Hearing Board as recommended by council. The purpose of this amendment is to remove an obsolete reference to hearing board members' rule within Rule 4B4 that has been rendered unnecessary by the prior adoption of Rule 4C, thereby harmonizing both subdivisions and clarifying the board's consent calendar processes. Any second to the motion? Second by Mr. Pearman. Any discussion on this motion?
Again, I'll reiterate, the chair does not give a reason why he took it off consent. At least the minimum.
The discussion is germane to the motion on the floor. The motion on the floor is approving the proposed administrative amendment. That's the discussion should be germane to that.
Okay, and I don't think that language shall have the discretion to move the item applies at a hearing. It is prior to putting it on a consent or not consent hearing. It should be under 4C3, you know, not for at a hearing. That's two different scenarios here, you know, prior to a hearing and then at a hearing. Mr. Larson, you want to add anything to it, or you don't see a difference?
Well, I might not fully understand it. To me, 4C3 dictates the procedure before a hearing, and 4C4 it pertains to once a hearing, you know, at a hearing. And I think it covers all the scenarios. And I think between what you all adopted in 4C3 and 4C4, the fix today is not intended to change anything. It's merely to clean up the provisions to be consistent with each other.
Any further discussion on this motion? All right, hearing Dr. Abraham, your vote.
Aye.
Ms. Verdugo Peralta,
No.
Mr. Balakapalan,
No.
Mr. Pearman.
Aye.
Ali votes in the affirmative. The motion is hereby approved on a 3-2 vote. And let me just state this for the record. I've never received a request from Ms. Verdugo Peralta seeking to have an item removed from consent in 1 year. Let the record clearly reflect that. I've never
Okay,
received this.
may I
Excuse me,
speak
excuse me,
afterwards?
excuse me, thank you.
Okay,
My time on the floor.
okay.
And we're going to adjourn after I make my comment for which I didn't make before. Mr. Balakapalan sent one request through the clerk. I never received anything other than a sentence. I never received any detailed context with respect to the request to have the item heard. Again, I want to be very clear. If anybody viewing or reviewing the minutes, if you know this hearing board, you realize we're not perfunctory agents or rubber stampers of anybody. And I resent the notion and the connotation that we would move in a very perfunctory manner. If anyone knows me, you know that I don't engage in such behavior. And so again, I want to thank you for your time today. I allowed everyone to speak. This is not going to be a debate or go back and forth. I say my piece at the end. We're adjourned at 12:50.